Yes, so in the last class we were discussing about the court of record, right? Hello. Yes. Why not you give me your textbook, please? NCRT. So what do we understand the court of record? Yes. What do you understand by court of record? We had discussed about this in the last class. Yes, we had just started. About judicial review. We had discussed about judicial review. Yes. Future evidence. Yes. So the cases which are resolved by the Supreme Court as well as the High Court, they are given the status of court of record, which means these cases are recorded. Whatever judgment is given, whatever evidences are used, whatever process of procedure has been followed by the Supreme Court or the High Court, it is recorded. Why do you think these cases must be recorded? Why these judgments must be recorded? Yes, it is. Yes, it is used as a reference. And these references are known as citation. What are they known as? Citation. What do you understand by citation? क्या होता है बच्चों citation? Yes, very good. So when you get a similar type of case that has been, running in the High Court, and if a similar case had been previously solved by the Supreme Court, then the one who is fighting the case, the lawyer or the advocate who has taken the case to the High Court, he will use the Supreme Court case as a citation, as a reference. He will tell that, see, in the previous such case, which is quite similar to the present case that is going on, this case, this type of judgment had been given, this type of evidences were shown, and as per those references, on the basis of those citations, the judgment is further given by High Court also. Followed? If suppose a judge says that, no, I'm not going to see the references that you are giving me, will that be allowed? Why? There's a proof, okay. So what? Okay. Suppose let's take an example. In Madhya Pradesh High Court, one judge for a particular case, he says, I'm not going to follow whatever citations you are giving me. I'm not interested. This is my court. I'm the judge of this court, and I will do whatever I wish to do. What do you think Supreme Court will do for that? They can take an action. Yes, very good. They can take an action. Because whatever the citations the advocate is referring, be it of the petitioner side or the defendant side, दोनों side में से कोई किसी का भी advocate हो, अगर कुछ भी citation refer कर रहा है, कुछ भी reference दे रहा है बच्चा, so क्यों दे रहा है? Because it is something which has already occurred, which is a precedent. What is it? Precedent. यानी पहले कुछ ऐसा हो चुका है, और अगर उसकी बातों को इफेक्ट नहीं किया जाए या कहा जाए कि हम इसको नहीं मानेंगे, तो इट इज अ पनिशेबल ऑफेंस. वो जो जज ऐसा कहेगा कि हमें साइटेशन नहीं मानूंगा या ये रेफरेंसेस को मैं वेटेज नहीं दूंगा, he will be punished under the contempt of. Understood what is court of record and why it is important? Online students, have you understood too?
Yes, ma'am.
Any doubt in this part?
No, ma'am.
So you can note this part, then we'll go further. Right? hardly 2-3 words you have to write. Be fast.
Yes, ma'am.
Yeah.
Yes, ma'am.
Write fast more also. One point is left out under judicial review that I will explain to you now. See what it is, when you are talking about a judicial review, it basically means to check on something that has already happened. Judgment है, सुप्रीम कोर्ट ने दे दिया है उस जजमेंट को, पर उसको बाद में ऐसा लग रहा है कि उसने जो जजमेंट दिया था वो गलत दिया. अब इसके लिए क्या करना है? It's been formed, a judges some group, usually will be having 5 judges for judicial review. And this 5 judges that whatever they had given a judgment in the past, how far it was good. Because see, in India, the days are changing very quickly. There is circumstances that are changing. मान लेते हैं केस भले नहीं बदला हो, लेकिन सर्कमस्टेंसेस में बदलाव आ गया. उस समय उस केस के लिए वो जजमेंट देना जरूरी था जो सुप्रीम कोर्ट ने दिया. लेकिन काफी सालों बाद सर्कमस्टेंसेस में बदलाव होने के कारण ऐसा लगता है सुप्रीम कोर्ट को कि शायद उसने जो दिया है वो गलत दिया है जजमेंट, वो आज के तौर पर सही नहीं होगा. सो इन एनी कंडीशन में whatever it is, be a judgment of its own court, or it may be of some other court also which has already given a judgment and there is some mistake in that judgment, or if in case the legislature has given out some decision and that is not correct and it feels that the court has to intervene and the Supreme Court has to make some modification to that judgment, then the Supreme Court has that right under judicial review. This kind of judicial review has been already exercised in the past for 3 times. The first time जहाँ पे judicial review करना पड़ा था बेटा वो तब था जब princely states को, you all know we had a rule of king and queens previously. So when we thought of integrating our nation, सब states को एक साथ लाने की बात हुई, तो सबसे ज्यादा काम सरदार वल्लभ भाई पटेल कर रहे थे. उन्होंने integration of states में काफी he has played an important role. So समय क्या हुआ था बेटा? Will anyone like to give up the authority that they have? किसी को अच्छा नहीं लगेगा. सोचो आप सब लोग कहीं ना कहीं के राजा महाराजा हो और आपसे कोई कह दे कि कल सुबह से आप यहाँ के राजा नहीं रहोगे, तो आपको अच्छा लगेगा? Certainly, to make you guys agree for that particular thing, wherein you have to give up your rights on as a princely state, or you are no more a maharaja or a king or a authority person, then the country has to offer you, the government has to offer you something much better than that. तभी तो आप वो चीज छोड़ोगे. So in that situation, government had offered privy purses to all these princely states. Privy purse. What do you understand by privy purse? तो पैसे दे रहे थे. कौन देता था? Government देती थी in princely states को, because they have given up their rights as the ruler of that particular kingdom. So they used to get certain amount of money. शुरू में तो ये पैसा काफी ज्यादा होता था. It was a very big amount that they used to get per month from the government. But later on, generations by generations, ये amount को कम करने की बात भी रखी गई थी agreement. So it was well decided that this is how they are going to get money, and because of which they will be giving up their rights on that particular state they are ruling. But ये agreement हुआ, integration हो गया states का, and then later very soon it was decided कि भाई हम इनको कोई पैसे नहीं देंगे. तो ये तो गलत बात होगी. Yes or no? Initially, you are promising them that you will be giving some amount, and the government later on says that it will not give them any amount, because naturally the condition, financial condition of the government was very, not very strong that time. So it needed funds to, maintain the kingdom. So it felt that it's not good enough to pay them the money, and gradually it has to be reduced. तो जब रिडक्शन की बात हुई तो पहले तो लेजिस्लेचर में इसके लिए वोटिंग हुई. वोटिंग में सिर्फ एक वोट की वजह से, एक वोट कम मिलने की वजह से ये प्राइवेट पर्स को हटाने की इजाजत नहीं मिली. It was still continued. But then president said that we will remove this private purse. Even though there is single vote less, we will still remove the private purse concept from India. But then what happened? जो किंग्स थे जिन्हें ये पैसे मिलने वाले थे, naturally they were offended and they went to the Supreme Court कि पहले तो हमें प्रॉमिस किया था कि पैसे देंगे, अभी नहीं दे रहे, प्राइवेट पर्स का कॉन्सेप्ट ही हटाने की बातें कर रहे हैं. तो सुप्रीम कोर्ट said no, you have decided to give them, so you will have to pay them this money. You cannot say no, or you cannot remove the clause from the agreement that you will not henceforth pay them any money. So इस तरह से क्या किया, पहले जो लेजिस्लेचर सोच रहा था कि हम इसको पैसे नहीं देंगे, उस कॉन्सेप्ट को सुप्रीम कोर्ट ने क्या किया, अंडर जुडिशियल रिव्यू उस लेजिस्लेचर के इस आइडिया को कि हम पैसे नहीं देंगे वो गलत ठहराकर उन्होंने पैसे देने कंटिन्यू रख दिए. समझे? हालांकि बाद में फिर से ये मुद्दा उठा, पार्लियामेंट में फिर से वोटिंग हुई और उस टाइम पे वोट्स काफी अच्छे मिले थे और अल्टीमेटली प्राइवेट पर्स का कॉन्सेप्ट काफी हद तक अभी कम हो चुका है. ओके, followed or not, any doubt in this part? Then one more instance where you can see about the judicial review जो Supreme Court ने किया है. The other case is about nationalization of banks. Have you heard about nationalization of banks? क्या होता है nationalization of banks? Anyone, online students, would you like to answer? What is nationalization of banks?
No, ma'am, no idea.
Okay, listen. Initially in India, we had around 14 private banks. Okay, let's take 14 private banks. ये banks जो हुआ करती थी बेटा, इसमें government का कोई interference नहीं था. They were private investors, private shareholders थे, जिनके पास पैसे थे, उन्होंने पैसे लगाए थे उस बैंक्स में और उनको इससे प्रॉफिट भी मिल रहा था, and they were running these private banks. But during the era of Indira Gandhi, she decided to make these private banks as a government bank. इन्हें nationalize करने की बात उन्होंने रखी. She wanted to make all these 14 banks under the government sector. अब गवर्नमेंट के सेक्टर में ले लेंगे तो नेचुरली इसके जो प्राइवेट शेयर होल्डर्स हैं उनको तो कुछ नहीं मिलेगा. दे विल बी अंडर लॉस. उन्हें क्या मिलेगा फिर? उन्हें कुछ भी नहीं मिलेगा. यस और नो? पीपल विल डिमांड फॉर मोर इंटरेस्ट. गवर्नमेंट बैंक से तो ज्यादा इंटरेस्ट लोगों को चाहिए होता है. They will demand for more loans in a better, lower interest rates. So naturally, the investors who had private shares in these nationalized banks, they started, protesting, and it ultimately landed up with the Supreme Court. And they said that we won't let our banks to become nationalized. We want it to remain private as it was before. जिन्हें चाहिए invest करेंगे. So Supreme Court was of the opinion that yes, correct, whatever the legislature has taken the decision to nationalize these 14 banks, it is wrong and we will let them continue to be a private bank. But later on again, there was a modification in the constitution, amendment हो गया, and ultimately they were nationalized. But Supreme Court in between it used its power of judicial review and it reversed the statement or the idea of the legislature of nationalizing these. Follow what is the concept? Then next comes third point that they have discussed. It's no talking when I am talking. Third is about a case which was in August 1999. बेटा इस एक केस आ गया. सुप्रीम कोर्ट में ये केस कौन ले गए थे? कुछ डॉक्टर्स ले गए. ये डॉक्टर्स क्या थे? They had completed their graduation degree and they had applied for their post graduation. पोस्ट ग्रेजुएशन के लिए इन्होंने एक एग्जाम भी अटेम्प्ट किया था. वी हैव एन एंट्रेंस एग्जाम फॉर पोस्ट ग्रेजुएशन. So they have appeared for this entrance exam and they have cleared. क्लियर करने के बाद They had an issue. What issue did they have? Good, now that they cleared their exams, now they will be a postgraduate specialized doctors. They had an issue. They felt that during those times they had brought up, reservation concept in the corporate. And the people belonging to SC, ST, and other lower caste, they were given an exception that even if they don't get 35% of score, whatever is required to pass that examination, they will still get their admission in the postgraduate course. So those kids who had appeared for that exam and they had cleared out, they were of open category and they felt that this is not good, this is not correct. Even 35% marks उनको भी लगा है, ठीक है 30% मार्क्स लगाए, कुछ तो क्वालिफाइंग मार्क्स आप लगाए उनके लिए भी, फिर आप उनको सीट दे देना, किसी मार्क्स के ही देना गलत हो जाएगा. So they took the matter to the Supreme Court and they said that so then this case further landed up in Supreme Court and there was a focus that merit should be given priority and not the reservation. Did you get me? Hardly anyone must have heard what I'm telling you. All were discussing among themselves. No? So then this was another case where priority was given for the merit. It was decided that the lower caste should not be given preference. Then it was further later on, again, it was amended with another constitutional parliamentary sitting and they made certain amendments and the reservations were brought to forth and there were some other terms and conditions also applied to it. So that's a different case, but in these three cases, first is there in the private purses for the places were reduced, and the second case was the nationalization of the banks. The third case, which you come to know, is about the merit for the postgraduate process in medical and engineering colleges. These three cases were the famous one wherein the judicial review was done by the Supreme. Any doubt in this part? Good. Any doubt online students?
No, ma'am.
Is there a student named Shivangi Kashyap also? No? Just a moment.
Yes, ma'am.
That is great.
Excuse me, madam, just a minute. Who is this Shivangi Kashyap? Shivangi, can you
Enter the
video? Avni Srivatsav. Who's this? Sorry? Avni, can you tell me, can you open your video? Can you on?
Oh, yes, Miss.
Who are you? You are from which batch?
Miss Nerul.
No,
yes,
we
miss.
don't have such students. That's why I'm telling. Avni,
Miss, we just joined the online sessions.
Sorry,
We just joined the online classes.
but no one
We
has
used to do
informed
it
me.
offline.
But no one has. Sorry, offline student, you joined for online.
Yes, ma'am.
No, then you should not.
No, miss. We asked our receptionist to do that too.
Sorry.
Miss, we went through the procedure to switch it to online classes.
Yes, class.
Your name is Shivani,
Oh no, Miss Avni.
Avni. And Shivani, who is this? Shivangi Kashyap?
Yes.
तुम लोग वीडियो क्यों स्टार्ट नहीं करते? Keep on your video, Srishti, Ayan. And offline students are not attend online. It is compulsory unless and until their parents should have to inform us.
Yes, miss, we did that.
Srishti, keep on your video. अगर वीडियो स्विच ऑफ है तो सीधा निकल जाने का.
Actually, miss, I just came from school, so I'm still in school uniform.
Let's continue. Come back to the class now. Yes. So what do you understand about bread? Have you heard about bread? Have you heard about bread?
Yes, ma'am. And they have the types of bits.
And
You can order.
order commands. Okay.
Yes.
Okay. It's not going to be and you have some authority to issue a writ. You have authority to issue a writ. Become serious and study. Authority to issue a writ, Supreme Court as well as High Court. Supreme Court as well as High Court. Both of them have the authority to issue a writ. Who will not have the authority to issue a writ? District court. District courts are not allowed. District courts are subordinate court, whatever it is. Subordinate courts, district courts are not allowed to issue a writ, whereas High Court and Supreme Court are allowed to issue a writ. Now, why do they need to issue a writ? In which conditions do they have to require to issue a writ? What makes them issue a writ? ऐसे ही आज कुछ केस नहीं है, चलो writ issue करते हैं. ऐसे करते हैं वो लोग. क्यों करते हैं writ issue? When somebody's fundamental rights are impeached, यानी किसी के fundamental rights के नुकसान पहुंचता है कोई किसी का, तभी ये writs issue होंगे. Then these writs are, it is passed by the Supreme Court and the High Court with an intention to safeguard somebody's fundamental rights. क्या safeguard करेंगे बच्चे? Somebody's fundamental rights. Yes, then it may be even one person's fundamental right, even a group of people's fundamental right, which might be this. It will be safeguarded by issuing this. Fundamental rights बेटा वो होते हैं जो आपके कॉन्स्टिट्यूशन का इसेंस है. जैसे कि right to speech, right of freedom of expression, freedom to live, right to life, right to liberty, right to life, freedom of liberty. आपको कहीं भी पकड़ के जेल में डाल देगा आपको चलेगा? No, नहीं चलेगा. क्यों नहीं चलेगा? Because that's wrong. No, they will have to prove something that they have an arrest warrant against you. Yes or no? Simply they cannot take you and push you inside the arrest. Yes or no? So if in case someone does that, the courts, the High Court or the Supreme Court both have an authority to issue a writ and cancel such wrongfully done, illegally done acts. Let's see how many types of writs do we have. How many writs do we have? 5 writs we have. So the first writ is about habeas corpus. Which is the first writ? Habeas corpus. So what do you understand by habeas corpus? क्या समझ में आता है habeas corpus? To have the body. It's a Latin word, right? So it says to have the body. To have the body. Which body would the Supreme Court or the High Court would like to have? Whose body? A person's body, yes. Which person's body? कौन से person का body बेटा?
Living man, a person with
A living, non-living, both are included. Yes, both are included. Dead person's body also. If suppose a person has died and the police has confiscated his dead body and they are not relieving it to the their families and the relatives, then they can also issue a writ कि मेरे family के जो person की death हुई है उसके body को इन्होंने wrongfully पकड़ के रखा. And in that case also they can get the body released.
Ma'am,
Yes.
so for living person, if the person is arrested, then the habeas corpus is issued.
Yes. When the person is wrongfully arrested, then also this is issued. But they asked me, that living or non-living, both the conditions it can be issued.
Okay.
Even if the person is, wrongfully arrested, there was an incident. Let's take an example. You know about Anna Hazare. He had done lots of, morchas and all, wherein he used to fast and he used to not eat until and unless he got his certain sanctions approved. He was fighting for Lokpal bill, right? You remember that? Anna Hazare beta. Yeah. So that's what happened to Delhi Commissioner of Police and the other home ministers, they wrongfully and unlawfully put him into arrest. And when they put him unlawfully into arrest, the Panthers party, which is a political party, Panthers party is a political party of Jammu and Kashmir. They went to the Supreme Court to get an habeas corpus writ issued. What did they do? They got a habeas corpus writ issued by the Supreme Court so that Anna Hazare could be set free from that wrongful detainment. But whether he will be set free or not, that will be decided later. Habeas corpus is such a writ wherein the court or the Supreme Court, whichever the court you have approached for, it will give a writ to that particular police officer or whosoever who has detained the person. They will ask him to come, bring that person to the court, show us on what grounds you have detained that person. Yes or no? Are you understanding what I'm trying to tell you? Hopefully. Then the next writ is, mandamus. Let's, before going to mandamus, one of you please read about what is given about habeas corpus. Please, one of you read. Class. Yes, when you read. You are sitting on the first bench. Silence, or I'm going to push you out of the class. Please have the body by this is such a list. The High Court or the Supreme Court can dictate the body of any person released if it has been unlawfully detained by any person or a group of persons or by the state. This is a great safeguard for the person detained. Because if a person is unlawfully arrested, then with whom he can go and approach? Now, did you get a doubt in this, Vita? If the person is under arrest, how can he himself go and ask the Supreme Court to issue a writ for him? Yes, sir. Anyone related to him and concerned with the arrest can go and get this writ issued. That is called locus standi. That means anyone who is concerned with that case, with that person, and is affected by that person's arrest can go and get the writ issued. Yes or no, followed or not? Then next comes writ of mandamus. Any doubt, online students? Did you get to?
Yes, ma'am.
Yes. Next comes writ of mandamus. Let me write 2 points about corpus writ. And lawfully detained person is released or is asked to come before the court, presented before the court. Who has the right to issue writ of habeas corpus? And High Court. Both of them have this authority. Next comes writ of mandamus. What do you understand by mandamus? Yes, it means we order in Latin. These are all words taken from Latin, and it means mandamus means we order. What must be the Supreme Court ordering? Tell me to the lower authorities to perform their duty. Perform a certain duty, yes or no? Now, why it must be needing the lower authority to ask them to perform certain duties? सबको तो पता ही है उनकी duties क्या है, क्या करना है, क्या नहीं करना है. तो writ of mandamus की जरूरत क्यों पड़ती है? If they are not doing something, yes, probably they are expected to do something and they are not doing that particular activity. In such scenario, what can be done? Writ of mandamus is, it is presented, it is issued. It means it is a command or an order from the Supreme Court to a lower court or an administrative authority to perform certain duty. That means they are expected to do an activity. Now let's take for example the lower authority needs to conduct an election, or it has to distribute vaccination to the people, and they are not doing that. In such scenario, what can the Supreme Court or the High Court do? It can issue a writ of mandamus and it can order them to do that particular task. Follow? Any doubt? Let me just write 2 points. We order. It means we order. Who is ordering? It's not we that we are ordering it. We
Ma'am,
can.
will you explain it again, ma'am?
Yes, what happened, beta?
Ma'am, will you explain it again?
I can't hear you. What is he saying?
He's saying, will you explain it again?
Again, okay, I'll explain it. We order means the Supreme Court orders. Class. Complete silence I want in my class. Mandamus means it orders the lower authority, anybody. Supreme Court may also order, or the High Court may also order the lower authority to perform a particular task, to perform a particular activity which has not been done. Okay. So, for example, let's take, I was just now discuss them with an example. Suppose an election has to be conducted in an area and that has not been conducted. Or if a vaccination has to be distributed to the people in a particular area and that has not been done. In such a scenario, the Supreme Court or the High Court, whosoever is concerned, they can issue a writ of mandamus and ask the lower authority to perform that task, which they are expected to do, but they are not doing. Then such task we can make them do, forcefully bhi kara sakte. Samjhe beta? Any doubt, online students? Mandamus mein?
No,
Yes.
ma'am.
Did you follow any more doubt in mandamus? Please ask. Anyone here having any doubt in mandamus? The lower authority. To perform a task. The next writ is writ of prohibition. What do you understand by the word prohibition? It's an easy, simple English word. Can you tell me what do you understand? To stop something. To stop something. Yes, very good. So whenever there is a particular case going on in the lower court and the higher court comes to the notice that this particular case does not belong to the lower court's jurisdiction. ऐसा कभी कभी हो जाता है बेटा कि हम कोई केस लेके जाते हैं और किसी हाई कोर्ट में चले जाते हैं उसके लिए फाइट करने के लिए. Later on it comes to the notice that this particular high court is not having its jurisdiction in this particular Supreme Court, or not Supreme Court, in the particular lower court where it has gone. अब ऐसा क्यों होता है? Because there are different high courts. Each state is having their own high court. We have territories drawn for each state, right? So this particular area falls under the state of Maharashtra. This particular area will fall under the state of Madhya Pradesh. These territories are well defined, but sometimes these territories are not completely well defined. These are some border dispute like regions. In such cases, what happens? They take the case to a particular court, and then later on it comes to the notice that it doesn't fall in that particular court's jurisdiction. And for that case, what they will do, the higher court will issue an order that no, ये आपके अंतर्गत नहीं आएगा, ये केस आप सॉल्व नहीं कर सकते, इसको आप रिजॉल्व नहीं करना चाहिए, आप इस केस को क्या कर दे, दूसरे कोर्ट में ट्रांसफर करा. Yes, so this is bit of prohibition, which the court is trying, higher court is trying to tell to the lower court to stop conducting that particular case, to stop hearing that case anymore. समझा? Any doubt बेटा? अब हम रोक रहे हैं ना, केस तो चल रहा है, जब केस चल रहा है तभी हम उसको रोक रहे हैं, तो हम क्या कह रहे हैं इसको? writ of prohibition. What it is called? Writ of prohibition. That is, the court is not allowed to continue the case anymore further. समझे? Any
Ma'am,
doubt?
so what about that case which has been stopped?
There might be such cases, but the citation for such case has not been given in your textbook, so it will not be discussed. But if you Google search about it, you might get some information about them. Okay?
Okay, ma'am.
Prohibition writ, as you know, it usually is not used because every court has its understanding what its jurisdictions are. Very rarely it comes that, you know, this particular case had been taken to a court and it is not having that jurisdiction to solve that case. Very rarely it happens. So in such rare cases, it will issue that writ. Well, very much people know that someone else is also there in the waiting room. Shiza Salim. Just give me a minute, I'll just tell you. What happened? Yes, so writ of prohibition is when the case has to stop. That means it is issued by this class. When the higher authority court issues to the lower authority court to stop something, that we call as writ of prohibition. Then we have one more writ which is more or less similar. That is the writ of certiorari. Writ of certiorari. What do you understand by this word certiorari? Yes, anyone? देख के तो बताओ कम से कम बुद्धि से. To be informed of what is going on. Yes, to be informed. मतलब हमें बताए आप क्या कर रहे हैं, हमें बताए. You all are studying? Yes? Yes or no? You all are sitting
Yes,
in the
ma'am.
class and you all are studying my topic which I am teaching you, Supreme Court. Yes or no? Yes. So this is to be informed about कि आप लोग क्या कर रहे हो. I am getting this information. Yeah, I got it. Yes. So you all are studying Supreme Court and I am informed of this fact. In the same manner, the Supreme Court also needs to be informed of what is happening. Suppose, listen to me.
Ma'am.
Yeah,
How is this different from a subpoena?
I'm telling you, please. See, when a writ of certiorari is issued, you know, it is usually issued after the case has already completed in the court. Take for example, a lower court is having certain particular case going on. It has completed that case. It has also given a judgment on that case. And later on, this writ of certiorari is issued. Why is this issued later on? अगर case चल रहा होता तो हम कौन सा issue कर लेते? Writ of prohibition issue कर लेते? Yes or no? ताकि हम उस case को रोक सके. But ये writ of certiorari कब issue करेंगे? जब इसका judgment हमें already lower court ने सुना दिया. समझ रहे हो? Students, are you understanding? Online students, offline?
Yes, ma'am.
Yes. So difference between writ of prohibition and writ of certiorari is certiorari is referred or issued when the case is already completed. Yes, and writ of prohibition will be issued when the case is still going on in the lower. Followed? Any doubt? Okay. Online students, any doubts, beta?
No, ma'am.
No? You write this about certiorari that the upper court or the superior court will issue this to be informed of what is going on. Any doubts in this whole bridge? Let's come to the last part. That is the co-warranty. What happened? What makes you laugh in my class? You want me to seriously push you out of this classroom or what? Suppose a person is holding an office and that person is found to have been produced, a false degree or false certificate, or his qualification is not complete enough, and still he has been offered that position, still he has been offered that authority. So whatever authority he is holding, whatever position he is holding is invalid. So no, because there are particular eligibility criteria which we need to follow before we appoint a person on that particular chair. Later on, if it comes to the notice that this person has been holding this position or this post falsifiedly or giving false testimonies or false information, in such situation, who warrant can be issued. This is a writ, which means by what order? By what order? किस अधिकार से आप इस कुर्सी पे बैठे हैं? ऐसे पूछना को क्या कहेंगे बेटा हम? Writ of who warrant. The court, the higher court, usually the Supreme Court and the High Court, they have this authority to issue it against a person or even a group of people who are holding that office, and it has been come to notice that it has been holding in falsifyingly or they have given false information. In such situation, they will call those people and they will ask them to produce the documents. कि भाई तुमने कौन से documents दिखाए थे तो आपको ये कुर्सी मिली थी, आप दिखाओ हमें वापस, and they will verify that. If after verification it comes out to be correct, then that person can continue holding it. But if after verification the person's documents are found to be false or they are found to be fake, then in that situation the person is removed from his post. Follow? Please note down these points in your book. Any doubts, online students?
No, ma'am.
Finish noting it now.
Yes, ma'am.
Yes. What happened? What did you write? So sure that you did understand. You know, as far as my knowledge is concerned. And it got slightly more given.
Yes, ma'am.
So we have the report chapter. Do you have any doubts relation with this chapter? Yes, students. Anyone having any doubts in this chapter? Reports. We go next to the High Court chapter as it is quite related. It can be easily correlated class. Why do I feel that you are talking amongst yourself and I am speaking here in myself only? There is no connection between you and me. Why is this here? And only in this class I feel like this. Are you not interested in studying? Should I stop teaching you? We don't take all these topics for self-study. Tell me, are you from? Is making fun so important for you? I can still hear those smiles there. Next, we have so we have got multiple signs, right? That we have what is there anything left out? Functions of input is left out.
And that order fields that occupy
I'll just tell you what's there.
information of fundamental.
So what is already been discussed? If this is that part is telling one of the number 205
Ma'am,
settlement.
your voice is not clear, ma'am.
Page number 205 settlement of disputes, original jurisdiction. One amongst you read. One amongst you read, please, fast.
Miss, your voice is cracking.
My voice is breaking. Are you not able to hear me well? Can you hear me now?
Yes, ma'am, it's fine.
Read.
The Supreme Court deals with appeals which are met to the respects of the original appeals with based on the different problem of the such as internship or using
Are you reading from page 205? Yes, continue.
we have the computation on civil and criminal cases of special appointment of law is there are achievements especially
Okay, tell me, is there anything that you have not understood in original jurisdiction part? We have already discussed about it, yes or no? Yes or no? Yeah. Then comes on appeal. On appeal means whenever the High Court is not giving certificate to be taking a case to the higher court, or that is the Supreme Court, then the Supreme Court can itself ask the case to be directed to the Supreme Court itself. Yes or no? अगर हाई कोर्ट ने सर्टिफिकेट नहीं दिया सुप्रीम कोर्ट के पास केस को ले जाने के लिए, तो क्या आप वहीं बैठे रहेंगे? नहीं, आप बिना सर्टिफिकेट भी जा सकते हैं सुप्रीम कोर्ट में अपना केस लेकर. Yes or no? I discussed about this in the previous class. Do you remember? That is the case on special appeals or special leave. Leave appeal by special leave they are called. जहाँ पे आपको हाई कोर्ट के सर्टिफिकेशन की जरूरत नहीं पड़ती है, and you can take the case directly to the Supreme Court. Yes or no? Then next comes the enforcement of fundamental rights. We have already discussed about this, that how the fundamental rights are enforced by the Supreme Court. We can pass a writ, we can file a public interest litigation for that. Yes or no? Then comes the administratory and supervisory functions. What are they? One of you read the first one, beta. Who will read? Is it so difficult for you to decide who will read the first point?
Appointment of officers and Supreme Court are made by the Chief Justice of India or Justice Administrator and email.
Yes, we have discussed about this. Who does the appointments of the Chief Justice and the judges of the Supreme Court? Yes or no? In the first class, we have discussed about this. Then next point.
And then the court is regarding the conduct of advocates and the
Yeah, this is one more new point that we have come across. Whatever the court is charging fees for particular case that has to be filed in the Supreme Court, or whatever the conduct of advocate or a lawyer has to maintain in the Supreme Court or in any other courts, has been decided by who? By the Supreme Court itself. Yes or no? You can't wear party dress and go as a lawyer in the court. Yes or no? You will not be allowed to enter. You have an uniform, you have a collar for that. Yes, black and white coat and of such things which are prescribed in the uniform. Yes, that's what you have to wear. You can't go there in a party wear, right? So that's what they are trying to tell us. Then third point, who will read? Fast. Third point.
Supreme Court ruled that Chief Justice of India's recommendation to transfer judges of the High Court was not binding on the government if the recommendation was made without consulting courts and judges of the Supreme Court.
Yes, if the senior most judges of the Supreme Court are not consulted, and then there is a decision made for transferring any judges, then that is not binding on the government. Did you get me? So Supreme Court senior most judges has to be consulted. ऐसा नहीं है कि आप एक को consult कर दिया दूसरों को छोड़ दिया. In such case, the transfer will not be held valid. So every senior most judge has to be taken into consideration and they need to be consulted. Yes or no? Any doubt in this part? Read the next point. Last point. Yes, whenever we need to file a case, in the High Court or in the District Court, there is lot of paperwork that is involved. We need to have the ledger paper, we need to have agreement. We need to, you think the bonded laborers and some women or such the weaker section of the society, will they be able to do all those paperwork? Naturally, they are illiterate. Some of them are illiterate. How will they be able to do these paperwork so efficiently and then take the case to the court? So for them, whatever the PIL has to be registered, it is not necessary that it has to be following a certain set of code of we sent even on an application, a written application will do, and their cases would be given priority. Last bench students, what are you doing there? Please pay attention. Okay. Now some terms also I can see here. Judgment is what do you understand by the word judgment? Decision or a order or a command given by the court. And after listening to both the parties, it's not that it will listen to just one party of the case and it will evidences that are presented, and therein after it will pass a judgment. What do you understand by decree? An order. Yes, an order of force of law. My God, you have aborted that one line, I think, from the textbook. But good, it's correct. So it's an order or it's a command which is given, which has a legal sanction. It has an authority of law. Okay. Then affidavit. What do you mean by the word affidavit? Yes. Anyone? See, if you, I don't know whether you have appeared or not, but if you, appear for some competitive exams, these days they have started taking an affidavit from you, wherein you are just asked to write whether you have cough, cold, fever, or you don't have them. You just have to tick mark that, and then you have to sign that paper and give that you have no symptoms of COVID-19. Even that is an affidavit, which says that whatever is written on this paper is true and to the best of your knowledge. ओके आपने उस कागज पे जो भी लिख के दिया है ना वो सच है और आपके हिसाब से वही सबसे करेक्ट इंफॉर्मेशन है जो आपको पता है. ऐसा जो आप लिख के देते हो ना बेटा, वो एक एफिडेविट होता है. मींस टू स्वेयर, टू टेक एन ओथ दैट व्हाटएवर इज रिटन ऑन दिस पेपर इज ट्रू एंड करेक्ट. Followed? Read out. Next, contempt of court we have already discussed. Notarize. Yeah, there is a notarize term also that they have given. What is to notarize? You have seen some offices, notary office. What do they do there? Agreement. Yeah, treaty agreement. Yes, and they also put a red color stamp there. Notarized stamp. That is called notarized stamp. That means whatever affidavit that you are going to give or whatever, or what happened? Time is over, but the bell has not rung yet. So let us finish this chapter first. So notarize means whenever you make an affidavit and you put a legal seal from the notary, then it becomes a document, a legal document. Yes or no? So for that, you can say it is a notarization. Contempt of court, we have already discussed. Yes or no? In the last class, we have discussed about contempt of court. Writ, we have discussed. And jurist, you all understand what is the meaning of jurist? Anyone who is having exceptional knowledge about law and legal rules. Yes. Only one meaning, that is a rule of law, that we will discuss in the next class, and then we'll begin with High Court chapter. Okay.